Welcome to another episode of SkiDD. Today we will be talking about the Schrems 2 ruling and what it actually means for you. So we will be discussing the case, the ruling, the EDPB guidelines, and the next steps. For every one of you, I have a link included of the CJEU ruling, and I also included a link of the EDPB guidelines. So let's just jump in. So what was the case? There was a previous ruling, the safe harbor decision, if you have heard about that, where the CJEU, so that's the highest court of justice in the European Union, ruled that transfer of data on that basis is illegal. After that, we had the Privacy Shield decision by the EU Commission, where they said that this is now another guarantee that data transfer to the US from the EU is legal. If a US company signed up for this Privacy Shield, and it was kind of like a self-certification. So in that case, Mr. Schrems, that's why it's also called Mr. Schrems or Schrems 2, Schrems, he is an Austrian citizen who uses Facebook. He signed up for Facebook, and he did not want to consent to the data transfer by Facebook Ireland, with whom the contract was signed. If you are a user of Facebook within the EU, then the contract between you and Facebook Ireland is being conducted the moment you sign up for Facebook in the EU. So that's why he opposed against that data transfer, and this led to the CJEU, where we had the first ruling, the safe harbor. That was a previous construction to make a data transfer between the EU and the US legal. So he opposed against that, and so then the safe harbor decision was ruled by the CJEU. However, he still was not satisfied, because with Privacy Shield, he still said that his rights were not guaranteed, or his data subject rights were not guaranteed in a good way in the US. So that's why now in July, the CJEU released the Privacy Shield, or the Schrems 2 ruling. So what exactly does the ruling say? The ruling says that the Privacy Shield is not an adequate safe guarantee for transferring data into the US. The standard contractual clauses that were previously already released by the EU Commission, standing for a safe data transfer between two companies, they were a level of protection. However, the CJEU also said that there are certain countries where those SECs, how you can abbreviate them, are not sufficient enough. So what you would have to do is have additional guarantees, and the level of protection has to be validated and guaranteed in every non-EU state. So this left, obviously, companies with the question, so what exactly does that mean for me now? So what companies then did was they consulted with supervisory authorities, they consulted between each other, but nobody really had a plan what the CJEU wanted to actually say with that ruling. So now in November last year, 2020, the EDPB released guidelines, and those guidelines are actually quite helpful for companies, and I want to tell you what those guidelines actually say. So what they say, their name is the Called Recommendations 1 of 2020 on measures that supplement transfer tools to ensure compliance with the EU level of protection of personal data. And I also included the link below. So what the EDPB says, or the guideline says, there are 6 steps to ensure the level of protection, and they are based on that ruling. So they're not something that they just invented, but they're based on the CJEU ruling, which makes it quite helpful for companies to act. So the first step is that you know your data transfers as a company. So what you should do is that you map all data transfers to third countries. And this obviously is easy for small companies, but very difficult for large companies, because in large companies there are thousands of contracts and sometimes also thousands of data transfers between EU and non-EU member countries. The second step would be that you verify the transfer tool your transfer relies on. So what does that mean? That means that every data transferred from the EU to a non-EU country has to be based on a transfer tool that is being summarized in the GDPR. So what you have is that, for example, it's the standard contractual clauses, or you have BCRs, like binding corporate rules, or previously you also had Privacy Shield for data transfers between the EU and the US, which was obviously overruled by the CJEU just now. Or you have like a Commission decision where the EU Commission says this country is considered safe from our point of view. And with safe, that always means that the level of data protection is equivalent to the level of data protection that is established by the GDPR. So after you completed your second step, in the third step, you would assess if there's anything in the law or practice of the third country that may impinge on the effectiveness of the appropriate safeguards of the transfer tools you are relying on in the context of your specific transfer. So this actually is, I would say, or from my perspective, one of the most difficult steps, because you would have to really dig into the law of the country that your data is being transferred to. And this requires actually a legal opinion on that country, and such a legal opinion would be quite difficult and also extensive to receive. So I would say this step actually takes quite long, because you would have to first establish on what kind of parameters do I want to check whether the level of data protection is being assured in that third country, right? On the fourth step, you would identify and adopt supplementary measures that are necessary to bring the level of protection and of the data transferred up to the EU standard of essential equivalence. So what that means is that you have contractual and organizational measures, and you have technical and organizational measures such as encryption. So the EDPB guidelines, they actually have some cases they discuss, and it's quite interesting if you want to look into it. So in the fourth step, you can read it for yourself. And what they mention is that a safe encryption or a sufficient encryption would be one of the tools that would also guarantee that your data is safe. On the fifth step, you take any formal procedural steps the adoption of your supplementary measures may require, depending on the Article 46 GDPR transfer tool you are relying on. So I would say 4 and 5, they're kind of interlinked to each other. Obviously, if you say that you take SCC, so the standard contractual clauses, and you have additional measures which you defined in the 4th step, then in the 5th step, obviously you would have to then ensure that those measures were actually taken. On the 6th step and last step, you will then reevaluate the appropriate intervals, the level of protection afforded to the data you transfer to the third country, and to monitor if there have been or there will be any developments that may affect it. The principle of accountability requires continuous vigilance of the level of protection of personal data. So that's also one of the most important steps, because not only have you defined your additional measures, but you also have to check whether those measures are taken and are effective enough. So it kind of requires like an audit process for you to then evaluate those processes. So what does that mean for you in the end? What are the next steps for you? That's probably the question you ask yourself. So what I would recommend is that you just follow the steps that the EDP guidelines established. So you, for your company, would have to establish all those steps. It will take some time. And what I also recommend is please do not wait. And if you have any questions, leave me a comment below. Please hit the like button and subscribe. You can also follow me on Instagram. It's skid_data. Thank you, and until next week.